Just item number 29 for listing in the next Tuesday, Mike. It was in the part one list, but somehow on several occasions it could not be heard because of
the part two.
part 229, my God. Let it be listed on 29th next week, my God.
Oh. What you do, you submit a mention memo.
Okay, my God.
After that,
May I please the Lordship, my Lord, I pray for listing of a motion matter, my Lord. It's a transfer matter, my Lord.
Huh.
Tomorrow, my Lord.
why?
Tomorrow, my Lord.
Motion matter.
Motion matter. We have filed it today, my Lord. And my Lord, although the order is dated 9/10/2024, yesterday it has been served upon the petitioner. And on the order, my Lord, on 9/10/2024, he was asked to join his new place of posting within 7 days from 9/10, my Lord. But he has received yesterday. Tomorrow, my Lord, motion. Oblige, my Lord.
May I listing form one admission made. It was last listed in the 2022. Monday, Mel.
Monday, next week will be difficult.
Next week, Monday, Mel. 28th,
On 4th now.
4th, Mel. Kindly before that, Mel.
Before that, only 3 working days.
30, Mel.
30.
30 October.
We'll have it on 4th.
My lord, I have similar prayer, my lord, in respect of 2 contempt petition, my lord, on 4th, my lord.
6.
My lord, 6th I have, then my lord,
8.
8th, my lord.
May I please, Lordship, to mention item 3 to 6, Lordship.
Yes.
Conducting counsel, Mr. Priya is in hospital, Lordship. He's undergone surgery, so maybe,
3 to 6.
yes, Lordship.
What surgery has taken?
He has undergone some lung surgery, Lordship.
I don't on request on behalf of the ARP.
Yes, Lordship.
When do you want?
So after 4 weeks, if Lordship allows.
Yeah. Oh.
Oblige, Lordship.
Please, your Lordship, I beg to mention item number 9, your Lordship. With the consent of the other side, your Lordship, it will be fixed after 2 weeks, your Lordship, if possible.
Your petitioner?
Yes, your Lordship.
Your good name?
T. Chetri, your Lordship.
Huh?
T. Chetri, your Lordship.
Item 9.
Item 9, your Lordship.
Your name is not here. You are appearing on behalf of?
Mr. A. Ganguly, your Lordship.
On request made on behalf of Mr. A. Ganguly, the council. List after?
2 weeks.
2 weeks.
Much obliged.
May I please, your Lordship? Lordship, I beg to mention for listing of a matter for orders.
Oh.
Lordship, the matter may come up on 25th. Actually, it's urgent regarding the non-payment of salary.
That is tomorrow.
20, yes, your Lordship.
Tomorrow will be difficult. Many cases are listed. We'll have it on 29th.
Much obliged.
May it please, your Lordship. Lordship, I beg to list 2 pending writ petition, Lordship, on 7th or 11th, any date, Lordship.
11th.
11th.
November.
Oblige, Lordship.
May I please, yes, Lordship, I beg to mention for item number 15, Lordship, this hearing matter.
Item?
15.
Yes.
It's seeking for.
We have no objection,
Taking
Lordship.
for-
He has already taken consent, Lordship.
Okay. You are appearing on behalf of?
Miss A. Talukdar.
On request made by Ms. A. Daluttar and the council. When do you want?
After 4 weeks, Lord.
Yes, sir.
Lordship, Lordship. Congratulations. Lord, one IA has been filed, my lord, long back for vacating the expert interim order. May I pray for listing in the next week, any convenience day, my lord?
Okay, 29th.
Give your blessings.
17 of supplementary.
May it be your Lordship. Lordship, as for last order, Lordship, there was a direction to produce the relevant record, Lordship.
You have all the three records?
Lordship.
Where are the records?
One was that letter from the district elementary education officer, DEO establishment of so and so. Where that the original suspension order was to be placed.
No, records.
Lordship, the original, there are three records, Lordship. The record from the director's office is also with me, Lordship.
These are records.
This is the original suspension order that was asked from the district elementary education officer, Lordship. The first one.
Have you read the para 2 of the last order?
On the next day, district elementary education officer, Dibrugarh shall place the record of district DEO established 2021 in original. Where the impugned suspension order of the petitioner was issued by the DEO Dibrugarh.
Oh.
That particular order has been sent to me from the DEO.
What are the
as of
records?
now. Otherwise, the record from the director is there.
I'm not asking about the director record. I'm asking about the DO record.
This was the record I have received.
With the para 2.
Lordship, I have it.
Then where's the DO? He's supposed to be present in court. In the absence of records, he is supposed to be personally present.
That. The original, that suspension order has been sent.
We did not ask for the original suspension order. We asked for the records where the suspension order is contained.
Lordship. And the other one is Lordship, the director's record.
Okay, that's part. Yes.
Lordship, that there is only one file. Paragraph 3 and paragraph 4, those two records have been mentioned, Lordship. The paragraph 3 record is that yellow flag one. Lordship.
Yellow one.
Yellow one. That was in fact communication reference.
Then
Then the entire file itself is the record of the paragraph number 4.
how about para 3?
That particular letter. There is no any two record file. Only
Okay,
one.
just one record.
Paragraph 3 is that yellow flag letter.
Mm.
And the entire record is of paragraph 4.
Have you seen these two orders?
Lordship.
7th October 2024,
Lordship.
written by the director.
Written by the director to the district elementary education officer.
Hmm.
Lordship to comply. Now,
Personally appear, produce the records in
Lordship.
original. Where is he?
Lordship, in fact, that letter that perhaps he must misunderstood the content of that letter. So he has sent that particular suspension order in original, Lordship. And
He is the district elementary education officer.
Lordship.
He understands
Lordship.
English.
Lordship.
Huh?
Lordship may fix next week, Lordship.
No. I'm fixing it to let him be personally present.
Lordship, it is from the Dibrugarh district, Lordship. It will be difficult.
I don't know how he wants to come. Let him come flying or what.
Otherwise tomorrow, Lordship. Tomorrow. Or on Monday.
Not Monday. There's already a judicial order and he's flouting all the judicial orders as well as the direction given by the director concerned.
Lordship. Tomorrow, Lordship.
Okay.
And in fact, Lordship, may I, in some, with the background of the case, Lordship, the petitioner here was appointed as a tutor. But the conduct of the petitioner himself is also not appreciable in.
That I've already put it in my last order.
Lordship. Because the school which he was supposed to join, he did not join there. And forcefully tried to join somewhere else. As a result, there was a criminal case against him. Yeah,
What happened? Have you taken instructions? Why he has joined in a different school?
Though Mr. Learned Councillor submitted that he has some joined in some other block, but that is not the fact, Lordship. As per my instruction, first of all, Lordship, the suspension order has not been written. I am not served with that, Lordship. So, Lordship, without
Have you withdrawn the suspension order?
So far as the suspension order is concerned, Lordship, the director being the appointing authority, now once this record is sent back to him, the office of the director, that process will start for revoking the suspension order.
without revocation, Lordship, the petitioner cannot join anywhere, Lordship. I am not served.
No, that was, Lordship, the subsequent development. The initial appointment, when the appointment was issued and the petitioner at the initial stage was supposed to join his base school, that instead of joining that base school, he tried to join some other schools, and as a result, this litigation has started.
Where is this office memo 10/7/2024? 10/7/2024. On the last occasion,
Lordship.
on 21/8/2024,
Lordship.
you made a submission that the suspension order in respect of the petitioner was withdrawn by office memo dated 10/7/2024.
Lordship. That 10/7/2024, perhaps that communication was placed on record also in the court
No.
file, Lordship. Perhaps, Lordship, if I'm not wrong. That communication was placed. Based on which I made the submission, Lordship.
10/7/2024 was just a letter
That was a letter, Lordship.
from the Director Elementary Education to the District Elementary
Lordship,
Education
Lordship, yeah.
to revoke the order.
Lordship, that communication was there, Lordship.
That is all. The suspension order has not been withdrawn.
And there was a direction from the office of the director to withdraw
Correct.
to the district elementary education officer
Uh-huh.
because the suspension order was also issued by the district elementary education officer.
But that is.
So that direction was there, but instead of withdrawing that suspension, the DEO again returned back to the director, being the appointing authority, the director, office of the director may withdraw the suspension order. So thereafter, that suspension order has not yet been withdrawn.
Then issue the withdrawal of the suspension order
Lordship,
tomorrow.
Lordship,
We will take up tomorrow.
Lordship.
And tomorrow DO will be present in court.
On Monday, Lordship. Tomorrow, I have some difficulty, otherwise.
What MS RS Mishra learned from
M. Nirola. Lord.
M. Nirola learned also for the petition. Stop. In terms of the direction passed by this court on 3/10/2024, the records in original of the Directorate of Elementary Education of Assam has been placed before this court. However, the records of the District Elementary Education Officer has not been placed. And instead, instead, only the
Original suspension order.
original suspension order has been placed by the Learned Standing Council, Elementary Education. Stop. Nor is the District Elementary Education Officer present in Dibrugarh, present in court today. Stop. Accordingly, list this matter on 28, on which date the District Elementary Education Officer Dibrugarh shall be present in court. Stop. Yeah. In the meantime, you issue the suspension or
Lordship, that communication I got.
you take back this file
Lordship. Your Lordship, was fixed
and by Monday,
Monday at
Ma-
2, Lordship.
not at 10:30.
Obliged.
Eighteen and 19. Admission part of it.
Yes.
The days fixed for producing the written argument, Lordship.
Written argument, reply by the petitioner.
Hmm.
So let them produce written argument.
आपको reply कोई बनी?
Reply to the
Have you met your
yes,
written argument?
yes, definitely. I am giving written argument. No?
When are you are submitting today?
Written just synopsis, not detailed written argument, just
The written argument I told you to submit.
yes.
Where's your written argument?
Exactly.
That is a written argument.
Yes, Lordship. On the last occasion, Lordship has directed the petitioner as well as asked to submit a written argument, Lordship.
Now, what is this? Records.
Record, Lordship.
Yash Sharma.
My lord, I have given written argument about only one because both are similar matter. Only thing is that the another one, Pradul Kumar Gaurav, his third year student was. That is difference. Otherwise, all the things are similar. That is why
1 minute. This Kumar Gaurav,
Kumar Gaurav.
this Yash Sharma is which year?
Yes, sir, is fourth year. And Kumar Gaurav, third year student.
Okay.
So, my lord. So, in brief, I would like to give the reply, or a proper reply also, whatever argument was made by them. So, my lord, to some of the arguments, my lord, the main issue involved in this case will be that whether the institute had followed the procedure as prescribed by them in their own code of conduct. That is number one. And secondly, whether the committee was formed lawfully. If the committee has been formed illegally, then this is entire proceeding goes. So that will proceeding. Then number three, whether there was sufficient compliance of natural justice. These things. Then whether there was anything against the petitioner to be punished by the institute. Whether there was any record, any evidence, anything against the petitioner to be punished by the institute. Then, of course, they have made some argument about letter dated 1/4/24. So what will be the implication of letter dated 1/4/24? So what will the implication of letter dated 1/4/24, my lord? That has to be seen. They want to say that writ petition become infructuous in view of letter dated 1/4/24, my lord. My lord has gone through the letter dated 1/4/24. What does 1/4/24 says, my lord? 1/4/24 only reviews penalty, which was passed by the SDC by letter dated 29/9/23. SDC passed penalty by 29/9/23, and POG had affirmed those penalties by letter dated 24/1/24. BOG have affirmed the penalty by 24/1/24. So what does letter dated 1/4/24 does? It has only reduced other penalties. That regarding hostel expulsion, they have removed it. They have removed the bar to attend the campus interview. That has been removed by them. And regarding my expulsion for 1 year,
The first letter was dated
29/9/23. 29/9/23. It is as at page number 22, annexure 2. That is letter imposing penalty upon me. So BOG affirmed that those penalties without any speaking order, just affirm the punishment. They say that in the interest of the discipline, the punishment is to be imposed. That is their only finding. They did not bother to see what are the findings, whether the finding is correct or not. They ought to have seen the findings. BOG like first appeal. So they ought to have seen it, whether the findings are correct or not, whether whatever alleged against the issue that is correct or not. Then comes 1/4. They want to say that because of 1/4, the entire writ petition become infructuous. My lord, how can that be, my lord? By 1/4, writ petition cannot become infructuous, my lord. 1/4, what is 1/4? Only review of penalties, 2 penalties. Rest, my expulsion remained there. On 1/4, they have passed order to review a few penalties, but they did not review my expulsion order. Had they would have reviewed, their story would have been different. They did not review. They said, yes, I was expelled till June 24. They said, yes, you join my register for yourself for next session on July 24. They did not touch it. So, my lord, that expulsion order remained there. That expulsion order, and they have done nothing to mitigate my grievances. My main grievance is that expulsion order. So that remained there. So question of becoming writ petition infructuous does not arise. They said that prayers made in the writ petition have been granted by us. Whether they have passed any order that your expulsion was incorrect, they did not pass that order. The order remained there. So my main core issue is my expulsion, the punishment that they are finding of the STC that I have committed some mistake. I have committed some violence. That finding is the core issue. That remained there. So how the writ petition can become infructuous? That is absurd argument. I did not expect such argument from the IIT. Then my lord, next issue, whether there was any, but whether there was any evidence against me, by which the IIT has relied, because my lord, the court's interference, it is a fact that the court will not interfere lightly in the matters of educational institute. That is correct. But definitely this honorable court will interfere when the court finds that the committee is not followed correctly. According to their own prescribed procedure, the committee was not framed. My lord, there are 3 deans. According to the clause of code of conduct, my lords. According to code of conduct, dean of student welfare has to be chairman, and the dean number 1 is to be one of the members, and dean number 2 is also one of the members. But here, dean was not there. Associate dean number 1 is not there. Associate dean number 2, the junior most person, she has been made chairman of the committee. Then there should be one students counselor should be there. According to clause number 4.1.5 of the ordinance, one student counselor should be there. Student counselor was not there. So they want to say that the 2 deans, they were not there, they were on leave. So that student counselor, she did not join the student counselor because they know the students, etc. They know the students' problems, etc. That is not the point. Point is that if the students counselor knows students very well, they come in contact of the students. Sometimes if they have any mental problem, physical problem, anything, student counselor are contacted. So student counselor is a very important part of the body. The institute had removed them. Otherwise, if had the student counselor there, student counselor would have advised STC about the students. No, this student is good considered. He is suffering from some problems. He is having some. That should have been around. What is the reason of keeping student counselor? There is some reason. So that was not there. So even constitution of the committee was illegal. Then, my lord, they violated their own code, 4.3.3 of code, 4.3.3 of the code of conduct. According to this code of conduct, STC will investigate the allegations and recommend disciplinary actions. SDC.
Let us see that code of conduct.
My lord, may I see page number 36?
Lordship, this matter already excessively heard by your lordship. If my
I am
left
replying to
friend
their
has-
argument. They should have patient. I am replying to their
If
argument.
my
I have
left friend is beginning all the argument again and again, then we need another time, lordship.
I have right to reply against their argument. No, what they have
The
said,
last argument
I
they have
am
already
saying-
replied, lordship.
I think
One
it's
minute,
very
1
unfortunate.
minute.
It's very unfortunate.
I'm just checking up.
It is very unfortunate. Why I am replying, why I have come to this,
Page.
then Marlet can understand. Page 36. Why I have to come here, Marlet will understand now.
Page 36 of what?
Page 36 of the petition, my lord.
Huh?
Read petition.
WBC?
WB 674/24. WBC 674/24.
Yes.
My lord. 4.3.3.
Page 36.
Page 36. WPC 674, my lord.
Oh,
Page 36.
that is not there.
Page 36 of the petition, my lord. My lord.
What?
My lord, main petition, my lord,
One-
IA, my lord.
one- Is this
There are
the
so many
IA?
IAs also, my lord.
Oh, this is IA.
This is applicable for both Kumar Gaurav and Yes Sharma. It will be applicable for both.
No,
674.
674. Oh. Yes.
My lord. Wait, hello. Hello, कृपा कर दीजिए रजिस्ट्रेशंस पर रेस्पोंडेंट बोली my lord. Here, my lord. Page clause number 4.3.3. Institute level, my lord. Violations at the institute level include those in issues pertaining to Indian IPC within or outside campus, those that can affect the IITG community at large, or those that affect the property of the institute itself. For all such major acts of indiscipline which may have serious implications on the general body of students and which may warrant a uniform and more formalized nature of investigation, SDC will investigate the allegations and recommend disciplinary actions.
Okay, I've seen.
My lord, so what the SDC will do? SDC will
No, no.
investigate.
That part I just wanted to clarify. But then you're repeating what you have
No,
said
not
earlier.
repeating, not repeating. What
Just give a reply to
No,
what
that
you
is-
have- where you have
my
not
lord,
covered
that
up.
reply I am coming. Why I have seen the reply? They want to say that here that they have made a very peculiar argument on that day that upon approval, the charges will be integrated by HOS to the concerned person. They said that charges means punishment. They want to say the charges means punishment. That is why I have again come into this. So can the charges mean punishment, my lord? Charges is charges. Charges are to be informed. After information of charges, I shall file, the show cause will be issued to me. I shall reply to show cause. Then there will be formal proceeding. Firstly, SDC will investigate. SDC will investigate and recommend that disciplinary actions should be taken. So what has been done in my case, SDC had investigated, and after investigation, nothing has been done. Directly punishment imposed upon me. Can that be done? It is unheard of. Nothing has been done. SDC called me on 16/8. Investigation was made. Every person was there. Investigation was made. Thereafter, they were required to either they will appoint some fact-finding committee, or they will recommend that action should be taken against these students. Then it will be sent to Senate. Senate will approve it. Then charges will be framed and charges will be communicated to the concerned person. My lord, your lordship has decided one case of IIT, my lord. What was there in this case, my lord? Your lordship's case, my lord. My there, your lordship held that. It was held by your lordship that it is 2024 Supreme Guwahati 971. Recent case, my lord, 7/8/24. In that case, my lord, that was Padugu Deepika.
That earlier case.
Yes, that case. That's why that the girl had expired. The students had went outside the campus. Students had went outside the campus. The girl had expired. In that case, my lord, the institute cannot say that charges means punishment, my lord. In this case, what has happened, my lord? The institute has firstly issued them notice, suspended the students, Thereafter, they have called, there was an investigation. Thereafter, after investigation, the charges were approved by Senate. Again, they have sent so cause to the student concerned. The student has applied the so cause, and after so cause, the matter of again sittings were there. So all the procedures were followed. The procedures were followed. So the institute cannot say that their interpretation is that charges means punishment. So my lord can see what has been done by the institute in that case. Even that was not done in my case. And in that case also, your lordship found that there was violation of natural justice because the fact-finding committee's report was not supplied to the students. So your lordship has rightly held that there is violation of natural justice. In my case, nothing has been done. Only investigation and thereafter punishment. So that is unheard of. So there is violation of their own code of conduct as well as violation of also their code of conduct as well as natural justice. So they cannot say that charges means, they wanted to say charge means the punishment. How could charge means the punishment? Under what a dictionary or how? And then they say that interpretation is right of interpretation is of the IIT. Where is the question of interpretation if the words are clear? You have to investigate, charge is to be framed, charge is to be intimated me. Thereafter, normal proceeding will go. So this is, my lord, the judgment passed by your lordship in the case of IIT on 7/8/24, my lord. 7/8/24, my lord. Then, my lord. Which judgment you are referring? That you have argued the case. This is
That
Pudugu Dipika.
Pudugu Dipika.
Pudugu Dipika, where the student has died in the hotel room. So, my lord, then my lord, they have referred one decision. One decision, that is Bhavaramesh versus Central Board of Secondary Education. In that case also, my lord, may kindly see it. The court does not say that there cannot be at all interference by the court in the matter of university. Here, what is said, my lord? Then, my lord. So in that case, whatever procedure was followed in that case, my lord, everything, all the procedure followed, only they did not supply the copy of fact-finding committee, and lordship have rightly come to the conclusion that they should have disclosed the evidence against the accused. So there was violation of natural justice. But in that case, my lord, notice by suit, firstly notice by suit, the students appeared, then fact-finding committee was appointed, fact-finding against before fact-finding committee about the petitioner appeared. Thereafter, the fact-finding committee recommendation will be sent to the STC. The STC again issued so cause notice. So cause notice was given. The written so cause was filed. There again the university IIT wanted further so cause, further reply on some other points. That was submitted. Thereafter, again they have been called for hearing of the matter, verbal hearing. Thereafter, the hour was passed. But in my case, only one notice by one call, by phone call and by email just appeared before the STC on 16/8, and I appeared, submitted some statement that on the basis of that investigation, no further inquiry, nothing has been done, no so cause, just next time judgment is. That is the thing. Okay. So, my lord, that is very unfortunate. Then they have relied upon one judgment, my lord, reported in P. Bhavaramesh versus Central Board of Secondary Education. That is the judgment of Madras High Court. They have replied, my lord. They have relied upon this judgment, my lord. But this judgment also says that the question is whether there has been fair play. The question is whether there has been fair play. If head of education issues had not in any way acted unfairly, there is no reason why the action taken cannot be sustained. Who will participate in the inquiry? So, what is then fair play should be then? Yet there is no fair play. Nothing has been, even so much was given to me. No fair play. And even one student, I do not understand how one student had been given just mild in punishment, only for 6 months expulsion of the hotel, no other punishment. And that student was actually involved in violence, and he admitted his violence. And there are several students who have stated, yes, that student Boni Hajarika was involved in the violence. He has beaten Adesh Kumar Patra, but no punishment, only 6 months expulsion from hotel. And against me, there is nothing on record. They have passed judgment against me by saying that 29/9/2023, by saying that I have admitted my admitted my involvement in the violation. Then where is the admission? They said that I have it. So, my lord, there is nothing against me. Then, my lord, another decision they have relied upon was the Guwahati High Court decision, my lord. That Guwahati High Court decision, my lord. In the Guwahati High Court decision also, the court says that if the court feels that there are grounds to interfere, the court can interfere in the decision making of the institute. So it is a case where definitely your lordship will feel that there is grounds for interference, my lord. My lord, this is the case where even a layman, if given this, see, this is the record, whether this Yash Sharma or this Kumar Gaurav are involved in that, even a layman will say that no, they are not involved. So they are the educated persons of the institute. They are running a institute.
Yash Sharma, you are saying it's in the 4th year.
4th year.
Which semester?
He was at that time in 6th semester. 7th semester. 7th semester.
Now he is in?
Now, my lord, now again he is in 7th semester itself. Because
and Kumar Gaurav?
Kumar Gaurav, he was in 5th semester. He was in 5th semester, my lord.
Now also 5th.
Now 5th, my lord. 1 year has been lost. Now they want to say that every relief has been given, my lord. Expulsion of 1 year has far-reaching consequences, my lord. My lord, I have to sit with my juniors as a backlogger. As a backlogger, that is very humiliating, number one. Number two, all my colleagues, they are well placed. They have employed, they are supporting their family. And I am here again studying. They are supporting their family. I am studying. In work life also, always they want to say that no, there will not be stigma. There will always be a stigma. Why I have not completed within the prescribed period of passing the exam. Always I have to explain. And why did not? Because of the disciplinary action. Always there will be stigma in my career. Always that stigma has to be removed, my lord. The court can consider whether this order is lawful, whether they have actually passed the order by following procedure, whether there was anything against me. So the stigma has to be removed. It is not that 1 year has expired, so nothing has to be done. That cannot be. That is their argument. So now another judgment, my lord, another citation, my lord. I am placing, my lord. My lord.
You are placing the citation or referring to the citation made by them?
Now my citation. They have made 2 citations. I have referred their citations. And now I placed 1 citation, the decision passed by your lordship in that Pudu case. In my lord. Honorable Supreme Court, my lord, in 2000.
Which one you
Supreme Court, SCC. 2003 SCC, page 59, my lord. I have, it's like,
2000?
2003 SCC, page 59.
Para?
Here, my lord, it will para 19. My lord, relevant part, no, not para 20, my lord, para 20. Para 20. Relevant part is page 69, my lord. The relevant part is page 69. In matters concerning campus discipline of educational institute and conduct of examinations, the duty is primarily vested to the authority in charge of institute. In such matters, the courts should not try to substitute their own view in place of authority concerned, nor trust its view. That is not to say that court cannot at all interfere with the decisions of authorities in such matters. The court has undoubtedly the power to intervene to correct any error in complying with provisions of rules, regulations, or notifications, and to remedy any and manifest injustice being perpetrated on the candidates. So everyone knows that what will be in slow, what will be, but if the court finds that there is violation of rules, regulations, manifest injustice has been done, and there is violation of natural justice, in that case, court can definitely intervene, my lord. My lord.
Yes.
Then, my lord. In a case, my lord, of course, not, it will not directly similar case, my lord, but in the case reported in 2018 Supreme Allahabad, 2018 Supreme Allahabad, page 557,
2018
Supreme Allahabad, page 557. My lord, I am supplying the copy also, my lord. In para 21, my lord, by relying on the Supreme Court decision, the object underlying the rules of natural justice is to
Para?
prevent para 21.
Para 21's with petitions accordingly disposed of.
My lord, 2018 Supreme Allahabad, page 557, my lord.
557.
557.
557. This is 517.
517 is a 557. Give the 557. My lord, I am reading it. I shall supply my judgment, my lord. I am reading it, my lord. The object underlying the rules of natural justice is to prevent miscarriage of justice and secure fair play in action. As pointed out earlier, the requirement about re-recording of regions or its decision by administrative authority exercise quasi-judicial function achieves this object by excluding chances of arbitrariness and ensuring the degree of fairness. Re-recording of regions in the process of decision making, keeping in view of the expanding horizon of principles of natural justice, we are of opinion that the requirement to record regions can be regarded as one of the principles of natural justice which govern exercise of power by administrative authorities. The rules of natural justice are not embodied rules. The extent of their application depends upon the particular statutory framework whereunder jurisdiction has been conferred on the administrative authority, which with regard to exercise of particular power by an administrative authority. So here the court says that you have to record regions. In my case, my lord, no regions has been recorded, my lord. How I have violated, they have made allegations that you have violated these and clauses of the ordinance of code of conduct. But how I have violated, that is not there. That is not there. How I have violated, what act has been done to violate it, that is not there, my lord. Then similarly, BOG, in this case, my lord, the appellate authority has not recorded the region. So Senate has not recorded the region in this case. So they said that you have to record the regions in affirming the order of the disciplinary committee. You have to record regions. But Senate has not recorded regions. Similarly, in my case, even the BOG did not record any regions. So it is violation of natural justice according to this decision, my lord. It's except to party action, it will not have it. So, my lord,
1 minute, let us have the decision.
then again, my lord, they want to,
That decision.
my lord, that another, go on. Another decision, my lord, regarding the molding of reliefs, my lord. Regarding the molding of reliefs, they said that such and such reliefs has been given, so you are not entitled to any further relief. The suit petition is liable to be dismissed according to them. My lord, 1981 3 SCC. 1981, 1981 3 SCC, page 528, my lord. Here, my lord, para 5, In this case, my lord, para 5 is relevant, my lord. Para 5. Para 5 is relevant.
With the other decision that Allahabad Supreme Court, 2018 Supreme.
That is I have provided, my lord. My lord. In this case of 19,
Okay,
my lord.
your next case?
1981 3 SCC, page 528, my lord.
Yes. Para?
It is, my lord, para 5, my lord. In this case, my lord, para 5, my lord. It is true that the writ petition contained a prayer for quashing of gradation list insofar as it related to intercess in the ranking of the petition based the respondent number 3 and 8, and the petition applicant had also sought the issuance of writ of mandamus directing of respondents 1 and 2 to forbear from implementing the or acting upon said gradation list. But subsequent to institute of writ petition, just like in our case, subsequent to institute of writ petition, the central government has refixed the rank of respondent 3, 4, 5, 7, and 8, and placed them below the appellants, thereby redressing the grievance of the appellant in so far as is pertained to the ranking of the aforesaid respondents. It is therefore become unnecessary for the appellant to pursue his claim for reliefs in respect of ranking assigned to those persons. It was under those circumstances that the appellant submitted before single judge of High Court at the time of final hearing of the writ petition that he was pressing the writ petition only in so far as related to his claim for seniority over respondent 6. We fail to see how the fact that appellant has sought in the writ petition the issuance of writ of mandamus directing respondent 1 and 2 to forbear from implementing such act of provisional guidance and should will operate as preclude him from seeking lesser reliefs. So the court said that again, the court said that this honorable court can mold the relief. If one relief similar to our case, my lord, we have prayed for allowing us to attend hostel, we have prayed for allowing us to participate in such and such, all these relief. So subsequent to filing of the writ petition, they have given those relief. They have provided, they have reduced the punishment. That does not mean that our writ petition become infructuous. And we have to file another writ petition challenging that Lord Order 1424. Besides ignoring the crucial aspect, division bench of High Court has also lost sight of well-established principle that it is an action where a party has prayed for a larger relief in it is always open to court to grant him any smaller relief that he may be found to be entitled in law, thereby rendered substantial justice. The court can undoubtedly take note of changed circumstances and suitably mold the relief to be granted to the party concerned in order to mete out justice in the case.
Okay.
So they cannot say that because of 1-4 letter, the writ petition become infructuous and no relief can be granted. That cannot be said. I cannot file each and every time they will pass an order. I have to file a separate writ petition. That cannot be the law. Then my lord may kindly see the 2011 1 SCC. 2011 1 SCC. Supply closing. 2011 1 SCC. Page 484.
Yes.
Submit. 2011. My lord, in this case, my lord, a resolution was passed by government debarring the appellant from holding the office of the trust, and due to subsequent events, some of the reliefs has become inoperative. So in this case also, in para number 14 and 15, the Honorable Supreme Court held that no, resolution is still in force. So you cannot say the writ petition has become infructuous. Similarly, in my case, the punishment against me, that letter dated 29/9/23, that is still in force. That remained in force. That punishment has remained there. That does not mean that I have 1 year has passed, so punishment, everything is over. The stigma is still there. So I want to remove it. So it cannot be said that because of passing of 1 year time, because of 1 year of expulsion is passed, so matter is become infectious. That cannot be. That is still in force. So, my lord, then my lord, I may come to the well-established principle, my lord. Well-established principle of the law, my lord. 19 that if statute provides for a thing, if a statute provides for a thing to be done in particular manner, that has to be done in that manner, not in no other manner, my lord.
Yes.
It's same, they have provided, they have made a statute, they have made an ordinance of code of conduct which was applicable on the students as well as upon the student also. So they were required to follow that. If they want to conduct inquiry, they had to constitute the committee as per that institute, as per that clauses, and they had to make inquiries according to those provisions. It's not otherwise not at all. They have violated those clauses, my lord. That is 1999 8 SCC. 1999 8 SCC. Page 266.
Yes.
I don't. Well, concluding the thing, my lord, it is apparent that they have violated the code of conduct, their own code of conduct in making the inquiry. Entire procedure for inquiry is faulty. Then,
Which para are you relying on in this?
my lord, this 1999, my lord, that my lord, particular that ratio, my lord. It is in para 17, my lord. In para 17, my lord. In our opinion, insofar as election petition is concerned, proper preparation of election petition in the Patna High Court can only be made in a manner prescribed under Rule 6 of Chapter. No other mode of presentation of election petition is invited under the Act or rules. Therefore, an election petition could not under no circumstances be presented in register to say it is well settled statutory principle that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and no other manner. That is the main statutory provision. That is also their code of conduct is the rules followed by them, and that is framed under the act, under the IIT Act. The IIT Act has given them power to frame ordinance of code of conduct. So that has a legal sanctity. They should have followed it. How can it be that only one message is sent, you come to the SDC to attend STD. I came to attend STD. Just write down whatever you know about the incident. I have written whatever I know. Thereafter punishment. Thereafter punishment, simply. And they want to say that they have given full opportunity to defend. My lord, this is a case where interference of the honorable court is required, my lord. Otherwise, the court will not normally, the court will not normally interfere in the matter, but it is an extraordinary circumstance, my lord. And not only that, after doing that, my lord, they are delaying the matter. After passing the order, they continue to delay the matter. BOG, my lord, it is their argument, my lord. The BOC has to sit 4 times a week, 4 times a year. It is their argument, my lord. According to the law, they have made the argument that according to law, BOG has to sit 4 times in a year. So BOC has to sit quarterly for its meeting. But in our case, my lord, the BOG last meeting was June 23. June 23. It was due in September, or it could have been done in October 1st week.
That you've already argued.
Oh, that is better. So all delays are made. So, my lord, taken care of. It is a fit case to exercise the power. And then my lord, again they reply, my lord. One more reply, my lord. they have produced some record that of my current money attendance, my current things. Oh, attendance is very important, my lord. One thing, attendance. I would not have argued it regarding attendance, but my lord, regarding attendance, they have again produced false report before this honorable court. My lord, they have furnished some of the attendance sheet of students, my lord, where yes, they show that yes, Sharma is not signed. My lord, they have, it is a printed sheet of attendance. Name of yes, Sharma is not there. The teachers are not taking my attendance. Teachers are not taking my attendance. And even in one attendance sheet, your lordship will find that I have given in my written argument also. In one of the attendance sheet, my lord, at last, my lord, they have written my name, yes, Sharma. But I want to say that those attendance sheets are manufactured attendance sheets. Because while writing my name of yes, Sharma, they have not written my correct roll number. They have not even inherently making it hurriedly. In making it hurriedly, my roll number was not even properly rightly written. They have written my roll number also wrongly. My lord, that I can show, my lord. That is because of that is in reply to their argument. That is why I am showing, my lord. Otherwise, I would not have gone to the facts, my lord. In the reply, my lord.
Which reply?
Madam, my lord, I have not started my arguments with regard to Yash Sharma because I told on that time to the court that because of the positive of time, I said that I am filing my written arguments for Yash Sharma. Otherwise, I will substitute this point. Absolutely. And I stayed before this honorable court with all, yeah, my lord. If my statement is incorrect,
No.
let this.
He has argued yes, Sharma also, my lord.
1 minute, day. You have not completed your argument.
My lord, on that day, my lord, what had happened because of the positive of time, I said, my lord, I will file my written argument for Yash Sharma also. So certain points of Yash Sharma, which he is now picking it up. What I'm just making this point clear, my lord, if he goes to this point that these records have been forged something, and I'll request this honorable court to institute an inquiry, my lord. I'm ready to face. But what will be the outcome of that? That will also come out. I've explained. Those records are in front of him. I'll let him complete this argument, then I'll point it out, my lord.
No. He is making his reply. I'm not hearing you anymore.
My lord,
But if you have not concluded your argument, as so far as Yash Sharma is concerned, then I'll give you the opportunity to argue.
just because my lord had heard this matter and I did not want to trouble this court, few points, my lord, will require some clarity. That is the only thing which I'm praying.
Lord,
I'll not take more than 5 minutes
after
to clarify.
arguing the matter for 2 days,
No.
and he has argued yes, Sharma or Kumar Gaurav both. I have noted down the argument he made regarding yes, Sharma. He had made detailed argument of yes, Sharma, my lord. Even he had produced the current attendance registers of current attendance sheets of yes, Sharma also. Now he wants to argue the case of yes, Sharma. I am whatever I am replying, my lord. No, whatever I am replying, my lord. It's very disturbing, my
Let
lord.
us get everything clear. Yeah, tell me.
My lord, what I'm just saying this, there were certain common arguments with regard to Yash Sharma and Kumar Gaurav. Those common arguments I have made. With regard to this argument of attendance, which he is now making it up, that if the court wants, I will submit, my lord. Only the court wants and clarify these points. That is what I'm trying to say.
Okay. All right, my lord. I am replying only to the point he has argued regarding yes, Sharma. Regarding yes, Sharma, he has shown the attendance sheet of yes, Sharma, past attendance sheet, as well as present attendance sheet also. Yes, Sharma is produced, my lord. So on that point, I am replying, my lord. He cannot say that he did not argue for yes, Sharma. Yes, Sharma's argument is noted by me. He cannot say that he did not argue. So now there cannot be indefinite period of arguments granted to them. They have argued 2 days, my lord. And now they said they did not argue yes, Sharma. Why they did not argue yes, Sharma? This cannot be. It is very disgusting, my lord. It's page number 60, my lord. Page number 160, my lord.
Please.
Yes, I shall control myself.
Use
I am
your
very sorry.
parliamentary-
I am very sorry. I am very sorry. I am very sorry, my lord. I am very sorry.
Not expected from
No. I am very sorry. No. Actually, yes. Actually, I was very much surprised that they said that again they want to argue. That is sorry. My lord, page 160, my lord.
160 of what?
160 of the additional affidavit.
Yes, find it out.
160.
Of 674. No.
My lord, I am just
Just no 160.
160 আসেন কি? এইটু regarding that is in the
What was
to the all
it?
to the আসুন। I think it is IA. They have submitted that in IA, my lord. IA দিয়ে আরো কি আছে না?
Kumar Gaurav.
IA দিয়ে। 160 of the IA, my lord.
IA number?
IA number 1980/24. I am arguing this because they have argued about this regarding the attendance of Yes Sharma. They have argued.
Can say whatever it is. You cannot become unparliamentary from someone who is making the decorum with it. আমরা reply করছে না? Reply by that.
My lord. 160, my lord. Yes, Sharma. They have written name of Yes Sharma. Absent, 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 absent.
Serial number?
My lord, the printed serial number are 75. Thereafter, handwritten at last. Handwritten at last, my lord. Yes, Sharma. And roll number, my lord. 2001 to 1005. Roll number of Yes Sharma is 2001 to 1065. My lord, that is apparent from their own letter, exhibit number, annexure number 12, my lord. The annexure, that letter date 29/9/23. Yes, Sharma. Yes, Sharma. In annexure number 2, correct roll number is there. Annexure number 2, page 22. Annexure
Of the IA?
of the WPC, my lord. Of the WPC, correct roll number is there. That main letter, that letter date 29/9/23. The correct name, roll number of Yes Sharma is there.
Page?
Page 22, page number 22.
Yes.
The right number is 2001 to 1065. But here, so which Yes Sharma it is, I cannot understand. Maybe it may be some another Yes Sharma, I cannot know, but it is not my roll number. It is not me. It is not me, my lord. Then, my lord, I had already pointed out earlier also that while the matter was heard, the matter was being heard on 25/4/24, I had pointed out before this honorable court that I am attending the classes, but they are not recording my attendance. That is there in the order dated 25/4/24. The lordship will file it. That submission is recorded in order dated 25/4/24. It is not that now I am making some story. It is recorded in 25/4/24.
In which case?
In IA civil number 1163/24. At that time, I had clarified before the court that I am attending classes, but they are not recording my attendance. My lord, here. Learned Counsel submits that in terms of said direction passed by this court, the petitioner was allowed to attend the classes. However, his attendance was not being recorded by the college authorities. That reflected in order. Mr. Sharma, Learned Counsel further submits that at semester final exam is scheduled to be commenced from such and such date on that proximate date, the petitioner is not being allowed to take said examination. So by this order, I have also been allowed to take examinations. So that was recorded, that submission was recorded by the court. And on that day, my lord, they had made submission that out of 4 writ petitions, out of 4 writ petitioners, that is Yes Sharma, that Adesh Kumar Patra, Pradum Dixit, and Kumar Gaurav. 2 of writ petitioners are not attending classes as instructed by the IIT. That was their submission. And who was those students? According to them, it was Adesh Kumar Patra and Kumar Gaurav. So on that day, also they did not say that I was not attending classes. They, by submitting this, the two of writ petitions were not attending. That means I was attending classes as on that day, my lord. My lord, that submission as per instructions of IIT is on record, my lord. Nowadays, the submissions are being recorded, my lord. Submission are recording. That is in the website of the court, and that submission is in my custody also. It was downloaded from the website of the court. That submission, their submission on 25/4/24. So I was attending classes, and the truth has come out from them. And now they want to say on affidavit that I was not attending classes, and they have produced this attendance sheet by writing another roll number of a person. I don't know whose roll number is that, who is that Yes Sharma, I don't know, but I am not that Yes Sharma. I am not that Yes Sharma. That page number 160, that Yes Sharma is not me, because that is not my roll number. There may be another Yes Sharma, I don't know. So there is no question of any inquiry or investigation. The thing is clear before the apparent before this court. And I have replied to their argument in this regard. I have not placed any further argument. That was their argument, madam. I have recorded their argument. Madam. They have made that argument against that. I am not replying to any other thing which they have not argued. I don't want to give them any opportunity to continue the argument in an indefinite way. So, so my lord. So I think, my lord, they have also submitted the written arguments. We have also submitted. I think there is no need to further arguments, my lord. So regarding the may consider the case and pass the appropriate orders. And if they want to argue any further, in that case, I shall have the right to reply. Because I don't think that they would like to, there is like anything to argue.
Senior will limit the argument.
There is anything to argue. But if they want to argue, then I shall again have right to reply, and there will be an indefinite period will go on. That cannot be. There has to be some end of the arguments, my lord.
I'm grateful for my senior to directing this honorable court to conclude that.
I am not directing. They should mind their words.
Direction only.
I am not directing. They should
No,
mind
not
their
in
words.
respect.
They should
Not
mind.
in respect.
No, they should mind their words. I am not directing the courts. I am concluding my words, and I think that if they want to argue anymore, I have the right to reply. That is much. I am not directing
My
the
lord,
court.
I will just ask this honorable court because there are certain things which probably this honorable court requires a clarity. If the court requires a clarity, I'll just point out these things, man. Just for the sake of clarity, nothing else. This original record was placed before this honorable court on my last occasion. My lord will see that from that original record itself. I'm just pointing out that there was a page, the quiz which he has attended. That quiz which he has attended, the roll number which he has written there. This roll number was reproduced, and we have categorically stated that he has not attended a single class, one quiz he has attended. On that day, what happens, my lord, just clarifying this point. What happens in IIT system, my lord, the students during the semester, they jump they try, they sit in some classes, they figure out, they say, no, this class has not been, they take up other systems, other classes. That is the reason there is a credit system. Otherwise, there would have been semester pattern, people would have been coming and giving semester results and going. There is a credit system, my lord. So what had happened during the entire semester, people changed courses. Thus, in that original record, my lord will find after the printed names have been added. Original records are there before this honorable court. Names have been added. And whether these people have attended classes thereafter or not, that has been recorded by by the course coordinator himself. So, for instance, somebody call.
In that regard, my lord may see that the recording of 25/4. Recording of the argument of 25/4 that can be seen.
I have not interrupted anyone, my lord.
They are repeatedly
I have
interrupted.
not interrupted anyone. I'm just clarifying the point, my lord.
Always interrupted.
My lord, so what happens generally, my lord?
Record. Have you put?
Yes, my lord, this record of the origin, the part, it was submitted on the last occasion itself, my lord. With my instruction, my letter,
Too many reports.
my lord, I apologize, my lord.
My lord, they continue to produce this and that records from their custody, my lord. I have not.
They can verify it.
I cannot not a question of verifying. They could
Are
have
you
produced
challenging the record
no,
on
they
that
could have produced the records along with their affidavit so that
It
I
was
can
given
reply
on
it.
that day. Original record.
After submitting all the affidavit, they are submitting this and that paper, this and that papers. How
This
can I?
paper was given with the original record I have just produced, my lord. This record was there with the affidavit.
It's annexed in the affidavit.
My lord,
It's annexed in the affidavit.
my lord, it was there in the form of original record. It has come on the last date, my lord. Original record it has come. I have given the original record.
Yes.
Not my lord. It is my friend has submitted today on the last occasion. Or my lord, I will give my copy. My lord will look into my copy only. No problem. It is a letter addressed to my senior, Mr. R.P. Kakoti, dated 18/9/2024. There were two letters, video which the original records in connection to the attendance were produced. And with regard to the disciplinary proceeding, the records are there.
Not this. Is the one RP Kakuti address?
18/9/2024, my lord. Is it the date?
This is 13/3/2024.
It was previous, my lord. My learned friend will, my lord, will help this court, my lord. After the argument, I will not held up this honorable court, my lord. I'll just produce this and then probably. Yes. No, it doesn't. My lord, by this time, my lord, let me just address one point of Yash Sharma probably, which in the record it is already there. So what we have stated in that the flag markings are also there, my lord. That in the bigger file, I will point out. So, my lord, I'll just tell the court probably. So why there is a submission that only just a clarity that there was no admission by Yash Sharma ever. There was an appeal by Yash Sharma to the director, whereby he has admitted of him being drinking alcohol and smoking. That
I
record is
am
also
interfering
there.
here. I am interfering here. In my record, I have not found any such admission.
That
Let them
obviously
show.
will
Let
not
me
be,
say,
because
let us
I
see.
would not have given
Now, let
to
us
you.
see where is it?
Let us, yeah, I'll show it to the
Let us see where is
Yeah,
it.
you take the file, I'll show it to him.
Where is it?
I'll
They have
just-
submitted their,
I'll-
my lord, they have submitted their affidavit.
Not for a moment, I'll just show it.
My lord, they have submitted their affidavit, counter affidavit, additional affidavits, two additional affidavits. In none of the affidavit or additional affidavit, there is no such letter.
That mention is there in the affidavit. I'll show
There
it
is
this
no
also.
such.
I'll show it that also.
Letter
No problem.
in the affidavit. I want to see in the affidavit.
I'll show it that also. No problem.
I don't want to see any stray papers. I want to see
You
affidavit.
may not want to.
Whether they have seen any affidavit,
1 minute.
my lord, that is why.
You are getting agitated.
Let me see. I don't think Yash Sharma has made any such statement.
See this.
I want to see in affidavit.
See this.
Whether
I'll show it to
no, no,
the court.
whether it is in affidavit.
It has been documented.
Whether it
this.
is in affidavit.
It is his document, his signatures.
Let us in affidavit.
In the
And-
affidavit, have
My
you
lord, I have mentioned in my affidavit that I will produce the original records. And the admission was there.
My lord,
Ah.
okay, let me see,
So,
which dates, let me see, let me see, which date it is. Which is date, what is the date? I want to say, what is the date?
I have shown
The HDC has passed judgment on 29/9,
because
HDC has passed 29/9/23. Whether on 29/9/23 there is any admission on the part of Yash Sharma?
Let me clarify this position. Let him say whatever he wants to say, then I'll clarify. I'll hold on.
Okay,
Let him clarify.
let him read the, I have not,
Yes, sir.
let him
So,
read the admission.
he has admitted before SGC, the oral hearings have taken place. There are 2 dates he have gone before SGC. He has submitted certain things orally. And thereafter, my lord, on Yash Sharma's letter to the director on 8th October 2023, before the BOG decision was taken, the authority of recommending authority after recommendation on 8th
minute.
October 2023, my lord,
letter, Yash Sharma letter to?
to the director as an appeal. His appeal against the SDC verdict incident on Ghat,
Dated?
8th October 2023. I hope this letter finds you in good health and high spirits. I am writing to formally appeal against the disciplinary verdict imposed against me by the Student Disciplinary Committee for my involvement in the incident that occurred in the Ghat on 8th August My name Yash Sharma and I am 4th-year student pursuing the degree. Para number 4, I'm just reading the relevant part. While it is true that I consumed alcohol, small amount of beer on that day, I remained in my control faculties throughout the evening to avoid any contribution to the escalation of the incident. I have not association with the fight happened. He goes on saying that I have happened to the fight and my intentions. So the consumption of alcohol on that day, why it started? The issue started with the consumption of alcohol. This gentleman is very smart. Yash Sharma is not someone who is he varied his statements places and places by understanding his consequences. So I pointed out this also, my lord. Thereafter, my lord, he pulled out that cigarette from the mouth of, that is also there. But I don't want to because his records, everything has been flag marked with the EA. My learned senior wants to see that he can definitely see the original records. Now let me
Right.
just clarify another
That-
small point.
On this point, I shall reply a bit, my lord. Let them complete. Let him complete, my lord.
This is this, my lord.
Let him complete.
So after, what is the procedure, my lord? A SDC, when it sits, it hears people orally also, because this is an informal setup of teachers who sits and find out about a situation. This is not in some formal investigation inquiry under Article 311 that argument has been made. It's not an Article 311 inquiry, my lord. So there are certain things which people say orally. Those have been recorded, and thereafter they have been asked that you submit your written statement. On some time, especially in the case of Yash Sharma, we have noticed that statements were subsequently trimmed out. Now, about this argument that just as a clarity, I had shown that Honorable Court on that day that out of 3 deans, 2 deans were on leave. Is it a case that if the dean is on leave, if the officer is in leave, that investigation will not be conducted? Is this the argument been conversed before this Honorable Court? With regard to the student councillor also, my lord, I have that original record is there, which says that the student councillor, they themselves had requested to the SDC, to the BOG, that we don't want to be part of this SDC proceeding. My lord will appreciate why it is so. People in trust, it is as good as me saying that I, being an advocate of IIT, will jump into an
My lord,
for
these
an-
are repetitions,
for an-
my lord. He's already made those
Let me
arguments of that
clarify
day, my
the
lord.
point. Probably will my
These are
learned
not
friend will hear,
repetitions.
will have some patience.
They are repetitions, they were repeating.
Yes.
Same arguments.
It is as good as, my lord, because this communication which happens between student councillor and the students are confidential in nature. Fiduciary, they themselves say, I don't want to be part of this. I conclude, my lord, I will not trouble this Honorable Court more. All records are there. If the original record, my lord, wants some
Okay,
clarity,
all right.
my lord will ask me. I'll point out everything.
Okay, I'll conclude.
My lord, only one thing regarding that letter of Yash Sharma, my lord. Only one thing regarding that, let me see the original record. Whatever the, only one thing regarding that letter of Yash Sharma. Only one thing. Only one thing. I'm not going to any other things. Only one thing.
You may check the entire report, sir. You would have told me. I would have put the entire
Not
report to you.
entire record. Actually,
If you would have told me, I would have shown you the entire record.
Actually,
before
my
the
lord,
day.
actually, my lord, whatever they are arguing, my lord, they have, if they would have not filed affidavit in opposition, that would have been different thing. They have filed affidavit in opposition. If they have filed affidavit, they cannot hide any record. They should have produced any record they rely in the affidavit,
Okay,
so
okay.
that I can
What
reply.
is the
My lord,
clarification
now,
you
now, my
are
lord,
not
now,
adhering any
now,
of the
now,
document
now,
of
my
Oh,
lord,
yes.
now, one minute. Now, regarding the letter, which they are showing, letter date 8/10/23, my lord. The letter of Yash Sharma, which they want to produce is 8/10/23, my lord. I don't know whether it is letter written by Yash Sharma or not. I am still doubtful. It is still doubtful, my lord, because first page is not signed, second page is there, and this matter has not been, this is a photostat copy, and this was not produced in affidavit.
Page
This
number
was-
122 of my affidavit, my lord.
Let me see. Let me see.
Which affidavit?
Additional affidavit which he was reading from.
120?
Of IA 1980.
IA. Let us see. Let us see. IA 1980. Let us see.
Page 122, para number 14. While it is true that I consumed
I-
alcohol, small amount of beer on that day, I remained in my control. Mentioned there.
That is
That is
their,
mentioned there.
that is their statement, my lord.
No, it is not statement. As it is categorically
That is their,
inverted commas are not statements.
my lord, that is his statement. They have not
Statement.
produced the letter, my lord. They have made a
That has been
statement.
noticed today.
They
No,
have
my
made
lord,
a
it is noticed
statement.
there on that.
They
That is on record.
That is what I said, that is doubtful. My lord, we have produced our letter to the,
They've produced that what he has stated in that letter in your para 14.
that I have denied in my reply.
So that you have denied, you have been given an opportunity to rebut. Then the records.
I have
we'll
denied
see
it.
the
My lord.
records,
Then, my lord,
after
regarding the
that
record,
we'll-
my lord, what is there? What is there? Firstly,
No, see, Shama, if
Let-
you want to see the records, I'll adjourn the matter, fix a different date, see the records and come back. Otherwise, I'm not going to wait here, waiting for you,
No,
going
no,
through record,
never,
making
no.
argument.
Not at all.
No. So what do you want? You
Only
want to
one
go
thing-
through, you want to go through records?
Only one thing I would
No,
like
no,
to.
Shama, do you want to go through the records or we conclude the argument?
My lord can take up the matter too also. I can go through the record.
No, no,
Then
if you want to go through the records, that I will permit you to take. go.
Definitely,
That I cannot deny you.
definitely.
So if
let
you want
him
to go.
identify which records he wants to see, the attendance
Which
record,
one- Which one do you
or
want?
he wants
I have to see the
record.
entire record. They are dealing.
Okay.
My lord,
You tell
only my lord,
that
only
argument
my
would have
lord,
been-
only my lord.
Okay.
Please,
then-
please, only my lord, one thing, my lord. Only one thing. At this stage, only one thing I would like to point out, my lord.
Hmm.
This is letter dated 8/10/23. After the decision of the SDC, after the decision of the SDC decision of 29/23/9/23. So after the decision of the SDC, this letter is there.
Mr.
So they-
Sharma, I've already asked you, you want to go through the records and then make your arguments next day, then I'll permit you.
All
But
right, my
if
lord,
you
all
want
right, my lord,
to
that's-
see that, you see one page, make argument, see next page, make argument, I'm not going to.
My lord, that is because of them, my lord. They have produced the thing, something.
On
They are relying
request-
upon
on
something.
request made by S. Sharma, the council.
They are relying upon something which is not in the.
When do you want, list on,
Very short date, my lord. Let it be very short date.
after the, after the Diwali?
Not so much date,
After
my
the
lord.
Diwali, let it come, my lord. I am also have. And let it.
No, let it
I
be.
will keep
Next-
all the
next
original records in my
week-
chamber, they will come
On
and-
29th, my lord, on 29th.
Next week, only 3 working days are there,
Yeah.
all these days are packed.
On 29th, my lord.
We will
After
have it
filing written
immediately after
arguments, my lord.
Diwali on 5th.
Then, my lord, let it be concluded, my lord. I don't want to go any much further, my lord. Let it be to be concluded and written arguments are before this honorable court.
Written arguments are already before this honorable. court.
I don't want to take them any more.
You have given your written argument.
I have given my
yes or no?
written. If
Okay,
if the honorable court can fix on 29, I can make
I'm not fixing it.
and then
If you want to fix it, we'll fix it.
on 29th. If
Immediately next
Written
day.
arguments are already
on
given
29th,
now.
my lord.
Because in the middle, you have this Diwali holidays and whatnot, 4 days holidays.
No,
My lord, on 29th, my
Only-
lord, I have some difficulty, my lord. My lord will not.
Immediately after
Let-
Diwali,
Diwali,
I'm
my lord.
fixing it. That is on the Saturday, Tuesday. This is a hearing day.
On which day, my lord?
Fifth.
Fifth, my lord.
If you want it, we have it. If we
All right,
can-
my lord,
we
all right, my
conclude.
My lord, original records will be
On
there
5th, my lord.
in my chamber, my lord.
On 5th, my lord.
Okay, on 5th.
Whatever
My lord,
record. If
The records will be there in my chamber. Some records, the original records have given with the court. If the court can return, then I can show it to him or he can look.
No,
into
what are the
court, say,
reports that you have given it?
Yes, my lord, I'll
You
check it.
just check it out.
Yes, my
with
lord.
the-
I'll keep
Yes, my
the
lord.
court and let him see it today and then probably will.
yes, my lord, that can be in today's.
You want to conclude or you want to continue the
No, no,
argument?
the court is fixing a date, now fifth, my lord. Fifth, my lord. All right.
Let him see the argument.
I can see the record, my lord. Whatever records are there, I want to see them.
Okay, hold on.
Lord, please.
Nothing.
Oh, okay. You have already filed your affidavit.
No, Lordship, after going to the affidavits of higher education, Lordship, there is some mistakes which we have to clarify it in our affidavit, Lordship. For that reason, we need to file clarificatory affidavit, Lordship.
Here is nothing, my lord, clarify. They clearly stated that the candidate is qualified. They already annexed the guideline, my lord. Regulation of 2010. And in this case, my lord, UGC has no major part to play.
UGC's role is also very important because we have filed the affidavit regarding the procedure for obtaining the PhD part also. UCC has never gone through the procedure which was lordship taken by the petitioner for obtaining the PhD. They have only gone through the lordship certificate issued on the PhD. On the basis of that, they have filed the affidavit. But how they have obtained the PhD and whether the procedure is followed or not, whether 2009 regulation is followed or not, their affidavit is silent, lordship. That's why their affidavit, the clarificatory affidavit is.
UGC's respondent number?
5, my lord.
And the whole
Respondent number 5.
PhD and MPhil is granted on the basis of the regulations given by the UGC. lordship.
Okay. Heard Mr. K. Ahmed, learned counsel for the petition. MS
K. Barbujari, on behalf of.
K. Barbujari, learned counsel appearing on behalf of Mr.
H. Omwa.
H. Amar, learned standing counsel UGC submits that after the affidavit filed by the Higher Education Department, the UGC requires to file another clarificatory application, affidavit. And therefore prays for
2 weeks, lordship.
2 weeks time. Praise allowed. List after 2 weeks.
Lease the matter on 7th, my lord. Seventh of November, my lord.
No. This on 12th November.
Lordship, can it be 20th November, lordship?
20.
Lordship.
21st, my lord, it is a hearing day, my lord. 21st is better, my lord.
21st. List the matter on 21st. Mr. SK Das, then counsel appears for the respond number 4. You furnish copies. You furnish copies.
Earlier also, directed, but on a single affidavit, I think,
20 of supplementary. Certification.
May I please your lordship? It was regarding NEET marks, my lord, dispute matter, my lord. My lord, your lordship, on last occasion, my lord, a dispute was regarding the answer key submitted by the writ petitioner before your lordship.
Where's the union?
Lord, I have filed a 2-page affidavit, only one, my lord, 2 page, my lord, marked as C, my lord. Leg C, my lord.
That actually. But the union is important.
Yes.
Who was appearing? H. Gupta.
Harish Gupta, he was there, my lord. He was.
He is in, my lord, the legs in court number 17, my lord. He is appearing in VC in Aizawl bench. He is appearing in the video conferencing through in Aizawl bench, my lord.
He is in Aizawl?
No, lordship, he is appearing through VC, lord.
Through video conference, he is
Video
appearing
conference.
from here, my lord.
From here?
Yes.
Yes. After a while, my lord.
After some time?
After some time.
Or your lordship may take it up tomorrow, my lord.
My lord.
Tomorrow, all those what matters are listed, no?
Medical admission matters are also
All listed tomorrow, so.
But the meeting after some time, my lord. After some time.
After some time.
No, later.
Item 7.
Wait, this is your lordship.
Mhm.
Lordship, with regard to this matter, we have the instruction that the promotion is under process, lordship. Another date may be given.
I am
appearing for the college. Now, if the promotion is under process, then their prayer is to initiate promotion process. Lordship will see page 17. More so that respondent number 3 to immediately initiate and process the matter of promotion of the petition. From the side of the college, I am appearing, it is already been done. only some documents are required. We are asking her with the ACR documents, we'll send it to the director. Therefore, the prayer is met. Look, therefore, it can be closed.
Lordship, for that I need to talk to my senior.
Okay, let's, on request made by MS,
AK Choppy, Lordship.
AK Choppy, learner counsel for the petitioner.
Otherwise, her promotion is under process and it will be considered.
There are some other ancillary prayers
Yes.
also. When do you want?
Lordship, maybe after Diwali.
Okay, after 2 weeks.
Deeply.
Bye, Lord.
Item 8. Item 8.
This matter, my lord, we have already filed an affidavit, my lord. This matter pertains to that, my lord. They are all illegal appointees, my lord.
Is it that B. Gogoi, same B. Gogoi,
My lord,
that standing counsel appearing as a private counsel, or different B. Gogoi?
different, I think different.
Okay, none appears for the petitioner. On 12/9/2024, none appeared for the petitioner. However, in the interest of justice, list the matter after 2 weeks.
2 weeks.
Item 10 and 11.
Lordship, in item 11, Lordship, this is a 2024 matter, Lordship. We need some time to file our affidavit, Lordship.
Pathak's case.
Yes, this pertains to recovery from pension.
Ah,
There is an interim order operating very.
okay. How about item 10, Raj Kumari?
Lordship, these two matters will be heard together, Lord.
Okay,
Item 10, perhaps pleadings have
Yes,
been
Lordship.
exchanged.
third, Mr. KP Pathak, learned counsel for the petition in WBC 2158 of 2024. Stop, Mr. D. Upamanian, standing counsel, higher education.
Yes,
Praised for how much time?
Lordship, 3 weeks, Lordship.
Praised for 3 weeks' time to file contra affidavit in WBC 2158 of 2024. Praise allowed. List after 3 weeks. Interim order,
Lordship had already extended it until further order.
or then not required.
Highly open.
12 and 13.
So petitioners are stipendiary teacher.
Mm.
They were appointed at Najira subdivision. They got salary up to 2016, March 16.
1 minute. Who are the other sides?
Only thing is, Lordship, in this particular case, earlier petitioner has approached this honorable court, and this honorable court has already directed to pay their current salary as well as area salary.
Mm.
Thereafter, Lordship, after 2016, again, they have stopped making payment salary.
2016,
March 2016,
till now.
till now. Because, Lordship, the petitioner's name has been included in a list of Sibsagar district of the access teacher. Some teachers were appointed against the sanction.
Elementary, who is appearing?
I think Lordship may not take this case only on the ground. After filing this case, we have challenged that we should be deleted from the access teachers list and we should be paid the area salary as well as current salary. That was our prayer in writ petition. After filing writ petition, the education department has filed an affidavit stating that our place was placed before the scrutiny committee. And in the scrutiny committee, they have appeared, petitioner has appeared. And thereafter, Lordship, they have taken a cabinet decision that those teachers who has received salary up to 2007 and those have completed the basic training, they will be given a supernumerary post and they will be given regular post. And those who have not qualified the 2007 salary but not completed the basic training, they will be appointed as a tutor. And those have not kept salary up to 2007, they will be not considered. That was stand was taken. Our stand was not like that. Our prayer is to pay the current salary as well as the area salary. And division bench of this court already given a direction. Lordship, kindly see there is a direction.
No,
From
that's
this honorable
okay,
court.
Goswami, unless the other parties are represented.
Only thing is, Lordship, we have also filed a separate petition challenging the cabinet memorandum because this cabinet memorandum is not applicable to us.
So where's that decision? Where's that? Which
Lordship has issued
petition?
notice to that in the petition because the after some delay we have to file this application because we have received the cabinet memorandum subsequently.
Then I think that one has to be decided
Lordship.
first.
Lordship.
Then we'll adjourn. You want it adjourned?
Lordship, that is why Lordship may take this matter along with that. That will be better. We'll give the number.
Oh,
WPC number.
elementary, nobody is there? And finance?
And already there is a division bench judgment to give current salary as well as area salary. And this court has already directed if that is not paid, they will be faced contempt.
No,
Lordship
that was in the admission column, isn't that? In the admission stage. But this is in the hearing stage. So it'd be difficult. So we'll list it after 4 weeks. Okay, on request made by S.K. Goswami, Learned Counsel for the petitioner. List after 4 weeks.
14.
To your lordship. In this matter, your lordship, the state government has introduced a scheme. The state fund scheme for grant of financial assistance to the volunteer education institution in the state of Assam. And as per that scheme, the petitioner schools were eligible, but they have been denied, thereby granting the benefits to the other similarly situated schools. So on being aggrieved, petitioner approached the Honorable High Court, your lordship. May I take your lordship to page?
Secretary? Who appears for secretary? Nobody.
The long pending matter, actually, lordship.
Yes.
Long pending matter.
Yes, you, Sharma, you are appearing for secretary?
So may I take your lordship to page 59?
1 minute. Any other respondents? Secretary. Finance is there. Are you ready, Shama?
Yes, ma'am. Yes, may I take your lordship to page 59, on being aggrieved when they being denied, that's the benefits under that scheme.
Page?
Page 59. That means the first litigation when they approached this honorable court. So may I read your lordship from page 60 onwards? Heard Mr. P. Sharma, Learned Counsel for the petitioner, as well as Mr. P. N. Goswami, Learned Standing Counsel Education. According to the petitioner, numbering 13, which are ventures high schools, they are entitled to get financial assistance as per the scheme formulated by the state government in the education department. It is their plea that their names were included in the list of 42 schools, but in view of the ensuing election, the financial assistance could not be disbursed. In the counter affidavit filed by the respondents, it has been stated that a proposal was made to provide financial assistance to the petitioner schools was mooted, but the finance declined to accept the same in view of the ensuing election. It has further been stated that after the election was over, the state government took a decision to discontinue the scheme. Mr. Sharma, P. Sharma, Learned Counsel for the petitioner, submits that the decision to discontinue the scheme cannot be operated retrospectively. He submits that since the proposal was mooted prior to the Model Code of Conduct came into operation, the said proposal is required to be approved by the Finance Department. Considering the grievances raised and as agreed to by the Learned Counsel for the parties, the writ petition is disposed of, directing the respondents to look into the grievances of the petitioners and pass appropriate order in accordance with law. Writ petition and disposed of. Thereafter, Your Lordship, based on this order, certain letters were issued. Amongst which, Your Lordship, the important letter is, Your Lordship, page number 66, Annexure Z.
1 minute. Annexure?
Annexure Z. Certain letters were issued, but the important is Annexure Z. This is issued from page 66.
Yes.
Yes. That was issued from Deputy Secretary to the Government of Assam Education Secondary Department to the Director of Secondary Education. Subjects when so,
reference to letter so and so. With reference to the subject and letter cited above, I am directed to request you to provide fund against the court cases from the balance amount of 2010-11 as the court cases relates to non-payment of assistance during 2010-11. Please treat this as most urgent. Thereafter, Your Lordship, most surprisingly, the next page, Annexure is, the order has been issued from the Office of Director of Secondary Education. Seen and read the order dated 29/2/2012 passed by the Honorable High Court. Number so and so. Also read the notification issued by the government for providing financial assistance during 12-11, Vite number so and so. As per the above guidelines, only those secondary school junior colleges which receive financial assistance during 10-11 shall only be eligible to receive financial assistance for the year 12-13. The petitioner institution did not get financial assistance during 10-11 and hence, as per the government guidelines, their claim for extending financial assistance cannot be considered by the Director of Secondary Education Assam. However, a letter has been sent to the government seeking instruction on the matter, Vite number so and so. Action will be initiated as soon as necessary instruction on the matter is received from the government as the matter relates to policy decision of the government. With this, the Honorable High Court's order dated so and so passed in, the petition number so and so is complied with. So challenging his order, Your Lordship, the petitioner again approached the Honorable High Court. That is, Your Lordship, the next page, page 68, Annexure I. This is the second round of litigation, Lordship. The operative portion starts from page 73. Page 73, the bottom portion, may I read? Yes, Your Lordship. From the reading of the order dated 29/2/2012, passed by this court in the earlier round of litigation, and also having regard to submission advanced and the materials on record of this case, it can safely be said that the petitioners were selected to receive financial assistance during 10-11. However, before the assistance could be released in favor of the schools in question, elections were held and there were some directions from the finance department not to disburse the financial assistance to the schools. Even though for some time, scheme may have been discontinued, the same will not wipe the entitlement of the petitioners to receive the financial assistance, which they did not receive because of certain events over which the petitioners had no control. More so because the scheme stands revived. Respondents cannot invalidate an antecedent claim with retrospective effect because of subsequent events. Accordingly, I hold that the petitioner are entitled to receive the benefits of financial assistance for the year 10-11. These aspects of the matter was not even considered by the Director of Secondary Education when he passed the impugn order dated 14/12/2012. In fact, he skirted and glossed over the issue rather than to give a response to the question posed by the petitioner. Clause 5 of the letter dated 5/6/2012, on which reliance is placed by Mr. Chesty, reads as follows. Only those secondary school junior colleges which receive financial assistance during 10-11 shall only be eligible to receive financial assistance for the year 12-13. In view of the determination made by the school that the petitioners are entitled to receive financial assistance for the year 10-11, necessarily and as a logical corollary, they would also be entitled to receive financial assistance for the year 12-13. The word received in clause 5 will relate to the entitlement for the period in question and not to the factum of actually receiving the money during the period. There being no dispute that petitioner was selected and thus entitled to receive the amount for the year 10-11. Failure to receive the money due to arbitrary action on the part of the respondents will not disentitle the petitioner to the legitimate claim of financial assistance for the year 2012-13. In view of our above discussion, the respondents are directed to provide financial assistance to the schools in question 13 in number for the year 2010-11 as well as also for the year 12-13. Such benefits must reach the petitioners within an outer limit of 4 months from today. The petition stands allowed with aforesaid direction. So based on this order, Your Lordship, certain orders were passed. Most important is, Your Lordship, page number 86, Annexure M.
Hmm.
86, Your Lordship. May I read? The order dated 10/4/2014 by the Honorable High Court in WPC number 5386/13, Jonasimul High School and 12 others, wherein the Honorable High Court has determined that the petitioners are entitled to receive financial assistance for the financial year 10-11 and necessarily as a logical corollary to receive financial assistance in the year 2012-13. And that financial assistance is to be provided to the schools in question, 13 in numbers for the year 2010-11 as well as 2012-13. Also read the proposal of Director of Secondary Education for grant of financial assistance to the 13 schools mentioned in the writ petition, the notification number PMS so-and-so dated 15/6/2012, and the order of Commissioner and Secretary, Secondary Education Department dated 11/12/2013 in so-and-so number. Now the decision. The 13 school mentioned in WPC number 5386/13 are entitled to receive financial assistance for the period 10-11, 12-13, and necessarily 2013-14, 2014-15 as they received recognition in 2010. This order is issued in compliance of the Honorable High Court's order dated so-and-so, passed in WPC number so-and-so. So based on that, Your Lordship, the very next page, Annexure N, 87. This is issued from the Deputy Secretary to the Government of Assam, Secondary Education Department to the Legal Remembrance, Judicial Department, Dispur, Guwahati 6. Under the subjects regarding government file number, under this file, the petitioner's matters was, dear Your Lordship, sir, with reference to the subject cited above, I am directed to inform you that this department endorsed a government file number so-and-so to your department on 31/2015. As the financial year 2014-15 is coming to a close, you are requested to kindly look into the matter early as the matter is High Court's urgent. This has the approval of Secretary to the Government of Assam Secondary Education Department. Now may I take Your Lordship to one more, there's Annexure Q, page number 91. Q, page number 91. This is issued from the Director of Secondary Education to the Secretary of the Government of Assam Education Department under the subject submission of proposal for sanction of financial assistance as per Honorable High Court's order dated 10/4/2014, passed in with petition number so-and-so, filed by the Janasimul High School and 12 others versus State of Assam and others, with reference to these two letters. In inviting a reference to the subject cited above, I have the honor to submit herewith a proposal for sanction of an amount of rupees so-and-so for providing FA to the Janasimul High School and 12 others and State of Assam and others in connection with the Honorable High Court's order dated 10/4/2014, passed in writ petition number so-and-so for the year 2010-11, 12-13, and 13-14. And this is the names of all those schools referred. And thereafter, in this connection, it is further stated that a proposal were submitted earlier to the government for grant in financial assistance to the above 13 numbers of institution by this official letter number 1 under reference mentioned above. There is a budget provision of rupees 35,000 crore for providing financial assistance in the year 2015-16. Government is therefore requested kindly to accord necessary sanction of rupees so-and-so. The expenditure is debatable to the head of the account, and these are, Your Lordship, may be skipped. Now, Your Lordship may kindly see the next page. Annexure R, page number 92. This is issued from Under Secretary to the Director of Secondary Education under the subjects regarding proposal for sanction of FA as per Honorable High Court's order dated so-and-so, passed in petition number so-and-so, filed by the Janasimul High School and 12 others. Under the reference of this letter, with reference to the subject cited above, I am directed to request you to kindly submit a detailed precise note about WPC number so-and-so, filed by the Janasimul High School and 12 others versus State of Assam and others for taking further necessary action by the government. Your report should reach this department within 3 days from the date of receipt of this letter. This may please state as court matter urgent. Now, Your Lordship, may kindly see this is the last relevant letter, Your Lordship. Next page, Annexure S, page number 93. This is in exchange to the earlier letter issued by the Director of Secondary Education to the Secretary to the Government of Assam under this subject regarding proposal for sanction of FA as per Honorable High Court's order dated so-and-so, passed in WPC number so-and-so, filed by Janasimul High School and others. Reference to earlier letter. With reference to the subject cited above, I have the honor to state that white order dated so-and-so, passed in WPC number so-and-so, filed with the Janasimul High School and 12 others, the Honorable High Court directed to provide FA to the schools in question 13 in number for the year 10-11 as well as also for the year 12-13. Such benefits must reach the petitioner within outer limit of 4 months. That this is important, Your Lordship. The Senior Standing Counsel advised to file appeal, but by his letter dated so-and-so, he opined that this should be appeal, Your Lordship. Appeal / review will not lie. So till this, Your Lordship, this matter relates to, and now may I take Your Lordship to my submission part, Your Lordship, para number 28. para number 28, Your Lordship, that the petitioner further begs to submit that after perusal of the Honorable High Court's order dated 10/4/2014, passed in WPC number so and so, as well as the proposal of the respondent number 7 for the grant of financial assistance to the petitioner schools, the notification number so and so dated so and so, and the order of the respondent number 1 dated 11/2/2013 in PMA so and so. The Secretary to the Government of Assam Secondary Education Department, respondent number 2, was very much pleased to pass an order number PMS so and so dated 8th of December 2014, thereby arriving at a decision by affirming that the petitioner schools in WPC number Iman are entitled to receive financial assistance for the year 10-11, 12-13, and necessarily 13-14 and 14-15 as they received recognition in 2010, and the said order was issued in compliance of the Honorable High Court's order.
What are they saying in the affidavit?
In their affidavit, Your Lordship, they said that, Your Lordship, para 7,
Page.
page 4.
Hmm?
Page 4, Your Lordship, their counter affidavit. The earlier act that was, Your Lordship, stepped down by this Honorable Court, and thereafter a subsequent act has come up in the form of Act of 2017. There are some venture education institution provincialization of teachers and services of teachers, Your Lordship. They said that under subsection 9 of section 3, save and accept an institution covered under Article 30 of the Constitution of India, which is already getting financial assistance or grants in aid from the government, no other private or non-governmental education institution shall be entitled to get aid or assistance from the state governments in any form with effect from the date of coming into force of this act. This has been clarified, Your Lordship, by the Honorable High Court in the second round of litigations very well, that they can't take it retrospectively because they have already been entitled to receive the same, because the scheme came into effect in the year 12/1/2011. And the act itself, 2011 Act, they came into force. They made a statement that they came into force in para 3, in
One
page
minute,
number 3.
1 minute. What is annexure 12? Page 12. What happened to this writ petition?
Probably this revision may be disposed. 575/2015.
You are the counsel, you are the one who annexed this order into your affidavit, and then you don't know what has happened. Here there's a restraining order not to give any financial assistance.
Yes.
Either to any non-governmental education, venture education institutions. All right.
Otherwise, madam, otherwise in our new act, page 114.
Whatever it is, what happened to this writ petition? You have any idea, counsel?
Yes, Your Lordship.
Any page 12 of the affidavit?
Page 12. This is regarding, Your Lordship, some other school.
Some other school, but it's already, have you read the last order? Interim order?
But however, Lordship, based on our second round of litigation, Lordship, that has clearly stated.
That second round of
Yes.
litigation is there.
Yes.
After that, this writ petition was filed. This court has passed an order both to the elementary as well as to the secondary education department. Now, the secondary, elementary, secondary, and higher education,
Yes.
not to disperse any financial assistance.
But we have been issued certain orders, Your Lordship, based on Your Lordship, the scheme. The scheme is that, Your Lordship, the scheme.
That scheme is there.
Yes, yes.
These
The
are
the matter is disposed on 3rd February 2015, my lord.
third of
2nd of April 2019.
What happened? Get a copy of that order.
Yes. Non-habeas for the petitioners on call, though the names of 3 councils for the petitioners have been reflected in the cause list, the matter was also taken up for the first half, but none appeared for the petitioners. It is seen that on last occasion, that is 28 to 2019, also there was no representation on behalf of the petitioners. Accordingly, the petition stands dismissed for non-prosecution.
After that, was there any prayer for restoration? Any application made for? You, Shama, you check up the status of this 575.
Yes.
And then come. After that, we can decide this with petition.
And otherwise, they have not continued as a financial assistance, as because they have not received any financial assistance.
That part has already been clarified by this court in the early second
round of
litigation.
litigation.
Yes, my lord. And moreover, in our Act 2017, it is stated that save and accept and institutions covered under Article 30 of the Constitution of India, which is
Mr.
already getting
Sharma,
financial assistance.
Sharma, that is an Act of 2017.
Yes.
This financial assistance is regard to 2010, 11, 11, 12, 13, 14, 14, 15.
In the 2011 Act also, same manner it is stated here.
There was already a proposal. Sanction also was
Yes.
south.
Yes.
But it was because of this WBC 575 that all the financial assistance was stopped. What happened to this writ petition? You say it was disposed for, it was dismissed for non-prosecution. Later on, was there any application for restoration of the writ petition? Whether a judicial order was passed?
And my lord, regarding their writ petition 5386/2013, 10/4/2000, order passed by 10/4/2014, Annexure I, page 73, my lord. Direction was given to the respondent authorities. And one time limit is given as outer limit of 14 months from today, but they have not preferred any contempt also to comply that matter.
They prefer this writ petition.
Prefer this situation, and the letters has been issued.
It was within, you want to contempt to go.
They have preferred this writ
Sharma,
in
what
2017.
submission are you making? You come with a proper instruction. What happened to WBC 575?
Yes.
2015.
Yes.
Heard Mr.
P. Sharma.
P. Sharma, Learned Counsel for the petitioner. Mr. U. Sharma, Learned Standing Counsel, Secondary Education, shall obtain proper instructions with regard to the outcome of WBC number 575 of 2015. Stop. List the matter when?
After 2 weeks, my lord.
After 2 weeks.
Yes.
20 of supplementary list.
Writ petition or copy?
Have you received the copy filed by the?
Yes, yes, my lord, I have received, my lord.
Have you verified?
My lord, this part, my lord, there are two, my lord,
Link.
two answer keys were published, my lord. So far as the revised answer key is published, my lord, that is not in dispute.
No. Have you received the copy of the additional affidavit?
Yes, my
on-
lord, I have received. I have received, my lord. They have stated that, my lord, they have downloaded it from the website. But the instruction, my lord, which I have received, my lord, the website name from where they have downloaded, that is not correct. That is the incorrect website, my lord. So, my lord, I think, my lord, we have to reply it by way of an
That's what I'm saying.
affidavit.
That's what I'm saying.
And
Because now he has categorically made a statement
yes,
that from this particular link,
yes.
I've downloaded the.
Now, my lord,
Now,
we
if
will-
you're going to controvert that
Yes,
statement,
yes.
then you'll have to file a reply.
Yes. My lord will, my lord. Today.
Heard Mr. A.K. Talukdar, learned counsel for the petitioner. Mr. H. Gupta, learned CGC.
My lord.
Praise for.
My lord, next week, my lord will.
Next week is just 3 working
My
days.
lord,
It will
my-
be difficult.
My lord, can
Press
fix
for
it on 4th, my lord, 4th.
Press for a week's time
Week's time. my lord.
to file reply to the additional affidavit filed by the petitioner on 26th October 2024. List on when?
4th, my lord. 4th November.
You want it on a miscellaneous day or a hearing?
My lord, 5th, my lord, then.
Fifth, many cases are this. I'll make it 7.
7th.
Okay. Any interim is that?
Yes, my lord, interim.
Interim order pass area to continue.
16 of Delhi list hearing.
Lord, in item 20, my lord.
Hmm.
My lord, the counseling will be over by 7th, my lord. So interim order may not be continued, my lord. Otherwise, one seat will be wasted, my lord.
No, where's Gupta?
My lord.
Then
No, otherwise, my lord, their claim is, my lord,
when is the counseling getting over?
From tomorrow it will start. So very few seats are left, my lord. So once the seats are filled up, my lord, it will be over, my lord.
Gupta, we can.
I can file it early also, my lord, if 30th.
30th, this will be difficult.
30th of October.
We'll have it on 5th then.
No, my lord, by that time, because
Let
fifth-
us wait.
my lord, 5th is the last date for joining of students. Thereafter, nobody can be admitted. Even with the order of the honorable court also, my lord. Otherwise, the seat will be wasted, my lord.
Then we'll have it on 4th.
Court will be also, my lord, difficult. My
We'll
lord.
see. 4th.
My lord, otherwise seat will be wasted, my lord. Because there is a guideline by the NMC and Honorable Supreme Court, my lord. After a certain date, my lord, nobody can be admitted.
Up
my
to
lord.
7th, you were saying.
No 7th. No 7th. From tomorrow.
No, no,
tomorrow-
up to counseling will go on up to 7th.
No, no, up to 7th it will not go. Because very few seats are left, my lord. So your lordship may take up on 30, my lord. 30, my lord.
30 is the last working day before
But-
Diwali. That
But
is the
otherwise,
problem.
my lord, seat will be wasted, my lord. Or your lordship may not, maybe please not to continue with the interim order, then, my lord.
How can we vacate the interim order?
Yes, my lord. That
How
is the-
can we vacate the interim order?
Then your lordship, please take up on 30, my lord, 30.
29th?
Yes, my lord, 29.
Gupta?
Yes, my lord, I'll try. I'll pass someone.
Okay, then what did I say? Miss heard so and so. Mr. H. Gupta, learned CGC prays for a short time to file reply to the additional affidavit filed by the petition on so and so. List on 29th.
Interim will continue. my lord.
Interim order passed.
16
The petitioner is not there. The date maybe expired.
You've got the records?
Yes.
I'm for respond number 5.
You're appearing with TJ Mandan.
Yes.
Who's JC Chowdhury? Who's JC Chowdhury?
I haven't seen that.
Have you seen him in the?
No, Lordship. I have.
Yeah, that's, none appears for the petition. Mr. S. Das, then it's standing counsel appears for higher education department. Comma. Mr. T. Chakravarti. G. Chowdhury, learned counsel, appears for the respondents 3 and 4. And MS P. Bhattacharya, learned counsel, appears for the respondent number 5. When do you want? Some urgency is there or not?
No, well, already, she's already working in another college, but I think there is.
Oh, that case.
Yes,
but
yes,
then-
yes. And rest of 5 is working since 2021.
Then why does she want to pursue this matter?
That then has to be clarified by the petitioner.
Otherwise, matter has become in.
Otherwise,
Yes. List after 2 weeks.
yes. What's all?
I've already passed the order, we'll take up on 5th. Any more cases? Finish.